Good morning and welcome to this webinar, which is being hosted jointly by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe, the CCBE, on the digitalisation of judicial proceedings, what European lawyers need to know. My name is Jonathan Goldsmith, and I am Senior Project Counsel with the European Lawyers Foundation. This webinar is taking place within the framework of an EU-funded project called TRAVAR, which is the short name for a project which covers training of lawyers in various areas of EU law. We have a lot of people joining us this morning, and so while people are entering the webinar, I will make a number of important announcements. Please, will you use the question and answer box to put questions to our speakers in English. We strongly encourage questions from all our participants. Questions will be answered if time allows, at the end of each session or at the end of the webinar. Please do not use the chat for questions. The chat is there to introduce yourselves, to say hello, but for questions to the speakers, please use the question and answer box. This webinar is being recorded, and the recording will be available on the European Lawyers Foundation's website after this session. The webinar is in English, but there's interpretation into French and Spanish. Please use the interpretation button at the bottom of your screen if you wish to hear the webinar in either French or Spanish. And finally, two very important announcements on which we get a lot of questions. So, first of all, the presentations. All the presentations will be uploaded onto the website of the European Lawyers Foundation after the seminar. So you don't have to ask us whether you will get them. They will be available on the website. They are packed with the most useful information. I've seen them. And so even if time does not allow to go through every detail, you can consult them afterwards. Secondly, if you want a certificate for completing continuing legal education, we do not provide the certificates. You have to approach your own bar for a certificate, and we will provide the bar with a list of all those who've participated together with your connection time. So don't ask us for certificates, approach your bar, and your bar will approach us for confirmation that you've attended. Now we'll begin the webinar. It's my great pleasure to introduce the president of the CCBE, Thierry Vickers, who will make some introductory remarks. Thierry was president of the Bordeaux Court of Appeal Bar Council, and then he chaired the Conférence des Bâtonniers, 2004-2005, and the Conseil National des Barreaux from 2009 to 2011. He's also one of the three authors of Règles de la profession d'avocat, which is in France the reference book on the organization and deontology of the legal profession. Thierry, over to you, please.
Thank you, Jonathan, and good morning, everybody. I'm very pleased to be able to introduce this webinar, which is devoted to the digitization of legal proceedings. Just under 10 years ago, the decision ended done by the Wisconsin Supreme Court in the Loomis case raised questions about the use of artificial intelligence in the judicial system. The fact that at that time a court was for the first time able to rely on an automated risk assessment tool during the sentencing phase to choose a sanction had provoked numerous discussion on predictive justice and the emergence of robot judges. It was really from that perspective that the use of AI in the judicial system was first considered. However, despite the importance of the principles that were debated at this time, 10 years later, this is not exactly the landscape that we have before us. The digitization of justice has not yet taken the form of the robot judge. In reality, it is the mastery of natural language, which seems on the verge of revolutionizing the way lawyers and the justice system operate. The CCBE and the European Lawyers Foundation were therefore right to join force in 2018 to respond to a call for tenders from the European Commission for the drafting of a guide for lawyers. The AI for Lawyers project identified natural language processing as the most promising area of artificial intelligence for lawyers. Indeed, the emergence of the third version of the ChatGPT model, followed by many others now, has enabled the general public to understand the impact of natural language processing. Just last week, Google announced the launch of Gemini 2.5, which will be equipped with a pop-up window of 1 million tokens. And Google is saying that the goal is to quickly increase to 2 million tokens. The limit of most of the available models today is only 30,000 tokens today. This gives an idea of the importance of this new development. Artificial intelligence tools have spread at an incredible speed, not from the professional sphere, but on the contrary, from the personal sphere and use. This situation, which is unprecedented, in fact, raises questions that are perhaps more trivial than those considered in the Loomis case, but are nevertheless essential for the digitalization of justice. Now that everyone has had the opportunity to experience artificial intelligence tools in their daily life, the question is no longer, will we use artificial intelligence in the justice system? The question is rather now, how justice could do without artificial intelligence. How long will it take to fully digitize? Because there is also a problem of pace. If the digitization of justice is not fast enough, it risks becoming overwhelmed because law firms and lawyers are adopting AI at a very, very fast pace. If the administration of justice does not modernize quickly, it risks also being confronted with anarchic developments. Why would judges be less eager than lawyers to exploit the advantage of artificial intelligence in their work? The objective of this webinar is therefore to present the state of the digitalization of justice in Europe and the projects for the next future. I would like to thank the various speakers who will be providing us with clarification. First of all, on the European Commission project, then on the work of CCBE in this field. We will continue after that by examining the situation in Estonia, which is one of the most advanced countries in the European Union in that field. And we will conclude with a presentation of the action of the Council of Europe, which has long been a key player in improving the quality of justice. I hope it will be a very useful webinar, and I thank you very much for attending.
Thank you very much, Thierry, for setting the scene so clearly and comprehensively of our coming webinar. We move on now to our first substantive session, which is the European Commission's plans for digitalization of judicial proceedings, and you will find out that they are extensive. Our speaker is Gösta Petri. Gösta is the Deputy Head of Unit and Team Leader for e-Justice in the unit which deals with digital transition and judicial training at DG Justice and Consumers at the European Commission. And this unit obviously is developing and implementing policy on the digitalization of justice and e-justice. Gösta began his career in the Swedish courts and parliament, but has been with the European Commission in various roles for over 20 years now. Gösta, over to you, please.
Thank you very much, Jonathan, and good morning to everyone. So I intend indeed to paint a broad picture today of the work we are doing in the European Commission, in particular then, of course, in the unit that I work, which is the unit in the DG Justice and Consumers dealing with a digital transition and judicial training. So I will talk a little bit about digitalization of judicial cooperation and judicial proceedings, indeed, and that is very much centered on implementation work that we are doing, and very concrete, and hopefully also useful for lawyers to know. But I will also maybe then at the end, if you agree, cover a little bit looking into this crystal ball for the future to see what else we can do in terms of digitalization of justice at EU level. You are all aware that we have since a couple of months a new College of Commissioners in place. We are working under the Irish Commissioner, Mr. McGrath, and we are in discussions with him, of course, what he could do in terms of digitalization of justice. But before that, indeed, I will focus on digitalization of judicial proceedings and cross-border judicial cooperation. So if we could move to the next slide, please. So we have here a legal basis, or a double legal basis, if you like. The regulation on digitalization of judicial cooperation, or we prefer to call it more shortly, the digitalization regulation, which is has the number 2023/2844, but it was adopted together also with a directive at the same time, but the directive is more of an accompanying measure to amend existing directive in the area of civil law and criminal law as required by the introduction of this new regulation. Next slide, please. Right, so the regulation and directive, they were adopted a bit more than a year ago, towards the end of 2023, and entered into force then on 16th of January 2024. So we've been having them with us for more than a year now. And we have therefore started the work on implementing the regulation and directive, and this is a big job, which I will tell you more about. But the objectives of this piece of legislation, it's basically to make use of digital tools and digital communication to improve the efficiency and resilience of cross-border judicial cooperation. On the one hand, between competent authorities in procedures like European arrest warrant, for instance, or that it's also to improve then the possibilities for individuals and parties to have access to justice, and more making available to them tools that will facilitate launching cases, basically, and thus improving access to justice. And obviously, the legal representatives of individuals are also going to benefit from this ease, but I will come back to that. And then, of course, there's also the objective to, by digitalization, facilitate carrying out various cross-border proceedings in the EU, and thereby reducing administrative burden and costs. No longer need for sending letters, postage, etc., etc. Right. Next slide, please. Okay, this is a very information-rich slide, because it just lists all the legal acts, legal instruments in civil and criminal law, EU civil law, EU criminal law, that are covered by this digitalization regulation. Basically, the whole idea here is to fully digitalize and make digital communication mandatory for all these procedures, basically, that lay down in these various legal instruments. So that's the kind of so it's not a regulation that covers everything in civil law. It has for some provisions, I will come back to that, it has a bit of wider scope in civil law, but generally speaking, it covers then the procedures that are listed. But it's a great number. It's 24 legal procedures in total. Next slide, please. So, right, in the beginning of the regulation, of course, we have defined the subject matter and the scope of the text, and it's basically Article 81 and 82 of the EU Treaty, so civil law and civil justice and criminal justice matters. But it, of course, only as regards cross-border cooperation. And then we cover here, of course, then electronic communication. And so communication which is not formalized or is not covered by the regulation. So then there are also, in addition to the basic scope, which is about electronic communication, indeed, there's also some additional rules that relate to digitalization of proceedings. In particular, most importantly, I would say, there is now, for the first time here in this regulation, an EU legal basis on a video conferencing for hearings and the participation of parties to the proceedings via video conferencing. There are also rules on electronic signatures and seals, basically stating that if you need to have a signature under the various legal acts, then we need a rule to say how they should be done in an electronic fashion, basically. We have also the kind of general rule on validity of electronic documents and rules on payment of court fees. But I will come back to these additional rules also in more detail later on. And then there are, of course, a number of amendments made to existing regulations and directives through these two, the digitalization regulation and its accompanying directive. Next slide, please. Okay, so here we come to basically the focal point of this regulation, which is the digitalizing electronic communication, and in first then electronic communication between competent authorities. So the idea here is that the regulation requires setting up a decentralized IT system for communication between those authorities. And there's it's also made clear in the regulation that this should be done using building upon what we already have in terms of tools for communication in the justice area. And as some of you may be aware, there's the e-codex system that was established by an earlier regulation, the e-codex regulation, which is a dedicated tool for communication in justice matters. This e-codex tool was developed by a consortium of member states with EU funding already more than 10 years ago. And it has been maintained by this consortium and adjusted and updated. But with the regulation at EU level then that was adopted in 2022, we basically kind of established the Codex tool as the EU system of choice for communication in the justice area. And the regulation also indicated that the EU-LISA agency would be responsible for maintaining the e-codex tool. And so that is happened then finally, the kind of the handover of the e-codex system from the consortium of member states to the EU-LISA agency. And the EU-LISA agency, you know, is established in Tallinn. It is for originally for large-scale information system in the justice and home affairs area. So like Schengen information system, visa information system, these kind of big centralized systems. But now this agency has also received the responsibility for the e-codex system, which is then based on a decentralized architecture. The official handover under the e-codex regulation to the agency happened last year on 3rd of June 2024. And as from then, the EU-LISA agency is responsible and also then involved in the use of e-codex at EU level, which has implications for this regulation. Because, as I said, the decentralized IT system to be set up here for all those 24 legal acts that I showed you on the previous slide, that has to be done with the use of this e-codex tool. Right, so the regulation requires setting up such a decentralized IT system, but more importantly, it mandates the use of this decentralized IT system. There's a rule indicating a mandatory use. You have to, between competent authorities, it is obligatory under the regulation to use the digital tools, the decentralized IT system. Of course, if you make such a mandatory rule, you also need to have exceptions. We all know that IT systems may be down for various reasons. So, and if that happens, of course, and if there is an urgent European arrest warrant to send out, it is possible to use alternative tools. Also, if if in the context of one of the legal procedures covered, it is necessary to transmit physical evidence, let's say, then it may not be obviously reasonable to require the use of the IT system. And there may be also force majeure situations which may require use of other tools. Then, in addition to that, those are the actual exceptions, but there is also a kind of alternative rule. If it is more, the swiftest and most appropriate means may be used also, if that would sort of be a more appropriate way to exchange information between the competent authorities. So the really regulation makes it use mandatory, but also makes it want to make sure that it's flexible to adapt to the actual needs of the competent authorities in the member states. And finally, there is also a rule about direct authority-to-authority communication. It may be, for instance, that the competent authorities are present in the same location in relation to an investigation, for instance, and then it would be maybe not very reasonable to ask them to send information via the system where they can just hand over the information directly if they are on the same spot, basically. Okay, let's move to the next slide, please. So I mentioned communication between competent authorities. The other important strand concerns communication between natural or legal persons and competent authorities in civil and commercial matters. So this is only for civil law. And here the regulation establishes something that we call the European Electronic Access Point. And this access point would provide then the possibility, and I underline the possibility, because we do not want to make it mandatory for natural legal persons to use a particular digital means of communication, because that would be a limitation of access to justice, clearly. So we want to provide this possibility for natural legal persons, and of course, very importantly, their legal and authorized representatives to lodge claims or requests to communicate with competent authorities electronically. And what we mean here, for instance, I will show you in a moment which use cases are covered, but typically and of interest to lawyers, I think, are like the European order for payment. If your client is not getting paid from a client in another country, there is the European order for payment procedure. And here we want to make the possibility to launch claims then electronically, fully, and even carry out the full European order for payment procedure fully online, basically. But as I mentioned, it's a possibility and it's not mandatory. Other means may always be used in this case. But thanks to the regulation, we will make it obligatory for the member states' competent authorities, for the courts, basically, to accept the communication via this European Electronic Access Point. And we are going to build this European Electronic Access Point on the existing European e-justice portal that you may already be aware of. So it will be available on the e-justice portal then for any natural legal person who wishes to launch a claim. Next slide, please. So here, again, a very, apologize, very detailed slide, but it's just to show to you that it's not actually all regulations and directives in civil law that are covered. It's those that are explicitly listed in the regulation, but it's still quite a few use cases. So among the priority use cases indeed is, I mentioned, European Order for Payment Procedure, also the European Small Claims Procedure, which for me, with a background in consumer law, I find a very interesting use case for this, allowing consumers to launch small claims in cross-border situations where they bought something abroad, maybe that it doesn't work properly, for instance. Among also the use cases, we have the other European procedures like the European Account Preservation Order or the European Enforcement Order. And I know also that certain requests under the Legal Aid Directive are also covered. But it's not only that. I mean, the first bullet point here explains that these European procedures, which are kind of fully covered by the European Electronic Access Point, but there are also other actions under a number of civil law instruments that are covered by this European Electronic Access Point. So recognition and declaration of enforceability, refusal of recognition, issuance, rectification, withdrawal of certificates. And then there's a specific one, the fourth bullet point here, in insolvency proceedings, the lodging of a claim by a foreign creditor under Article 53 of Regulation 2015/848, the insolvency regulation. This would also be covered or possible electronically then using the European Electronic Access Point. And then also maybe of interest is the communication between natural legal persons and their representatives with central authorities under certain regulations. Okay, next slide, please. So this was then I explained to you now what I called was the focal point of the regulation, namely communication between authorities and between natural and legal persons and authorities. But then I said also that there are other additional proceedings, additional rules regarding cross-border proceedings. And here we have then rules on the use of video conferencing. We have two provisions, Article 5 and Article 6 of the regulation. One provision concerns use of video conferencing in civil and commercial matters. And this is, as I said, this is a rule then that has a broad scope. It doesn't cover those instruments where there are already rules on video conferencing, which is the case in the taking of evidence regulation, the small claims regulation, or the European Account Preservation Order. So, but it covers the rest basically, and not only the legal instruments covered in the regulation. But the idea is to provide a legal basis for participation by parties in cross-border hearings, in cross-border proceedings. So basically, in a civil case, should be possible if a party is temporarily abroad, for instance, to participate in proceedings using video conferencing. And then we have a parallel provision then in criminal matters, but it has concerning then the participation of the suspect or accused person or convicted person via video conferencing. But this is a much more provision, much more narrow scope than the one in civil law. And the video conferencing in criminal matters, most importantly, does not cover the main trial, actually. It covers for instance, then it covers only proceedings in the mentioned in the annexes, which could include, for instance, European arrest warrant proceedings. Is one example of the kind of added value of that provision. Okay, we also have, when we talk about court here or hearings, this could also be applied to other officials, for instance, notaries when acting as courts under Brussels 1A regulation. And the VC provisions apply then upon request or is decided by the court on its own motion. Well, as I said, actually already, when a party or the representative is in another member state. And the court's decision as to whether to allow for participation by video conferencing would depend then on the availability of video conferencing technology for this purpose. The opinion of the parties should be requested, and the court is also requested to, or has to, consider the appropriateness of remote participation. Next slide, please. And these provisions on video conferencing will become applicable very soon, actually, 1st of May this year. So we hope that member states are ready for this. I think they are. They have notified to us their and the national legal provisions that they have in place. So I am confident that this will be working as of 1st of May. And we also remind here the national law applies as regards procedural rights of the participants. And next slide, please. Yeah, I mentioned also that we have rules on electronic signature and seals. There is a general reference to the EIDAS regulation, which you know is a regulation on electronic identification, signature and seals. Then we have the more substantive provision in the regulation, which says that if we have under one of the legal instruments covered by the regulation, like a European arrest warrant or a European investigation order, if there is a requirement for that a document or a form has to be signed, or if there is a requirement of a stamp, then we say that when sent electronically, the document has to be provided with a qualified electronic signature. And that is the kind of highest level under the EIDAS regulation. And similarly for an electronic seal, it also has to be a qualified electronic seal. For the situation of the communication of natural and legal persons with the authorities, using then the European electronic access point that I mentioned. There we provide for two alternatives, actually. Could either sign your form or document using a qualified electronic signature, like for authorities, or you could instead use an electronic identification scheme. And then if you do that, you have to, so you log in basically and authenticate using an electronic identification scheme, and then with a high assurance level under the EIDAS regulation. And then the other sort of ancillary provision here in the regulation concerns court fees, basically, or other types of fees. So if you launch a case using the European Electronic Access Point, the member states of the courts in the member states will have to provide the possibility electronically, which must be accessible via then the portal or the European Electronic Access Point so that you can pay the court fees electronically. Right, next slide, please. Okay, so here is then an explanation of the decentralized IT system and the planning. So it is a challenging task, of course, to adopt these 24 or digitalize those 24 legal acts. And the regulation provides for the adoption of implementing acts for the technical specification, basically, for this decentralized IT system. And this should be then done in 4 batches of implementing acts, counting from now until the beginning of 2031, actually. So it's quite a long work plan that we have ahead of us. But we've grouped them then, as I said, in 4 batches. And basically we have done 2 years to adopt the implementing acts for each batch, and then there's 2 additional years for the IT implementation before the decentralized IT system can go live for those relevant legal acts. So we have already entered the 2nd year of work on the first batch, which is European Order for Payment, Small Claims, European Arrest Warrant, European Investigation Order, and Freezing and Confiscation Order. So there we are in the process of soon adopting the implementing acts for those legal instruments. And we do all this in a committee with member states, actually. So this is what you usually refer to as a comitology procedure, where member states may provide support to the Commission in the preparation of those implementing acts. And then we have also this year started with the 2nd batch of instruments, which concerns then legal aid, European Account Preservation Order, insolvency regulation, and protection measures, both the civil and criminal protection measures, and rules on custodial sentences. And then it continues with a 3rd and a 4th batch, which I will not bore you with further. Next slide, please. Yeah, here is a slide about the comitology committee that I mentioned already, which assists the Commission in setting up the decentralized IT system. And the implementing acts should then contain the various types of technical specifications for the system. Next slide, please. And here's yet another roadmap on the digital implementation here, which also, because there is not only this regulation that I mentioned, which is the one that I work on, but we have also other regulation which follow the same logic and also uses the e-codex system. It's a service of documents and taking of evidence regulation. There's the e-evidence regulation, which is being implemented right now, and it's also a number of forthcoming legal proposals, the parenthood, protection of adults, and transfer of criminal proceedings, which will be implemented in the future. Next slide, please. Right, so now, because I'm speaking I have a couple of minutes left, I want to mention to you the Commission's future plans. So, as I said, we have a new Commissioner, Commissioner McGrath, and in his mission letter, it was in the mission letter from the President, it was indicated that Mr. McGrath has to prepare and for the College of Commissioner to adopt a strategy on the use of digital technologies, including of AI, to make EU civil and criminal justice systems more efficient, resilient, and secure. That's what this mission letter said. And the plan is that this strategy will be adopted by the Commission in the 4th quarter of this year. Next slide, please. And in this slide, I indicate a little bit what such a digital strategy could contain. And here we go way beyond, of course, digital proceedings that I started to talk about. So there are 7 strands of work here that we imagine that we could focus on. Mapping of data on digitalization and exchange of best practices. This is basically to find out more about where member states stand in terms of digitalization of justice, and also provide a kind of forum for member states to exchange best practices between them, so that all in the EU could benefit from the others' experience. We have the EU Justice Scoreboard, which is a very good data tool, which kind of shows a little bit where member states stand, but we want to continue that. So sorry, Jonathan, maybe I'm continue too long, since I see you popping up.
No, you see me indeed, and perfect timing. Thank you so much. But there are some questions, so
Okay.
if you're happy to wrap up now, I'll put the questions to you.
Right. I don't know if I should mention the other very briefly.
Very briefly, go on.
Okay. So basically, I mean, the president was mentioning the AI and just at the beginning. That's of course an important work strand to look at. You know, we have the AI Act, and there's guidance on high-risk AI systems to be adopted in February next year. So this is something we need to think about, and we provide input to this guidance. We're thinking about having an IT toolbox available to member states, also of various digital tools, including AI tools. We're also thinking about access to EU and national law, online access, and how to make judicial data more available for the training of AI tools. We're thinking what we can do more about video conferencing for hearings. Of course, that's an important area. And we're thinking obviously important for member states, how can we provide the best possible way of giving EU funding for digitalization of justice. That's going to be, we're negotiating, or will be negotiating soon, the multi-annual financial framework for EU, the 7-year budget. And we will see then how large digitalization of justice will figure in that. And then finally, of key importance to lawyers and justice professionals in general is judicial training on the use of all these tools, AI tools and other tools. Very important as well. Okay.
Thank you so much, Gesta, for your very clear and comprehensive presentation. Ezra Salmanli has put a couple of questions. I'm going to put Ezra's second question, which is, to what extent does the European Commission consider the environmental damage caused by digitalization, such as e-waste and energy consumption, when the pushing and promoting, for very understandable reasons, the e-justice? And how do you weigh up the damage against the benefits, like improved access to justice?
Thank you. Yes, a very relevant question. Well, probably, if I'm going to be honest, we don't consider those negative impacts enough, but we are required when preparing legislation like this regulation that I was talking about, the digitalization regulation. We are required before proposing legislation from the side of the Commission to carry out so-called impact assessments. And there we need to look at the different impacts of such legislation in terms of compliance costs for operators, in terms of the impact on public authorities, benefits in terms of making then the communication more efficient, but also environmental impacts we have to look at in that case. I think in this situation, I'm sorry. in terms of environmental impacts, we also consider the advantages of having digital communication compared to paper, for instance, in terms of paper consumption, transport, and so on. But of course, the energy consumption and environmental waste are also to be considered in that context. Sure.
Thank you. Very quick question then from somebody else. I don't know how you'll respond. DocuSign offers electronic signatures, advanced electronic signatures, and qualified electronic signatures. What is the Commission's view about these commercial offerings like that?
Well, if they offer a qualified electronic signature which is recognized as such under the EIDAS regulation that I mentioned, then they are perfectly fine to be used in the context of this regulation. I don't know particularly about this one, but if it is true that it offers a qualified electronic signature, then it's fine to use it.
Thank you. There are more questions, but we better stop so we keep to our time. Thank you so much, Kirsta. That was a really very interesting and clear presentation. Thank you so much.
Thank you. Thank you very much.
We move on now to our next speaker and our next session. This is to do with digitalization of judicial proceedings and the European legal profession. And we'll have two speakers for the session, even though the program only advertised one. Our first speaker will be Simone Cuomo, Secretary General of the Council of Bars and Law Societies of Europe. Simone's been Secretary General since August 2020. He first joined the CCBE in 2010 as a senior legal advisor, managing a range of CCBE committees in data protection and cross-border judicial cooperation. He's been closely involved for many years in EU policy developments regarding digitalization of justice, with a main focus on translating lawyers' needs into policies, and as well as ensuring procedural safeguards. So a part of Simone's presentation will be given by Anna Drozd, who's a senior legal advisor at the CCBE, responsible for, among other things, the IT Law Committee. Before that, she worked for a number of years as a policy advisor for the Brussels office of the Law Society of England and Wales. Simone, over to you.
Yes, thank you very much, Jonathan, for your introduction, and also to Gustav Petri for his very comprehensive presentation, which I can then also further use as a basis to a little bit approach it more from the bars or the lawyer's perspective as to how all these developments, how they impact the work of the CCBE. And the CCBE work is, of course, to do with making sure that lawyers' interest and lawyers' activities are ensured also in this whole digitalization effort. And I have a presentation which I will now quickly put on. Just a second for that. Okay, I hope it's visible.
Yes, you need to make it full screen.
Yes. So.
Perfect.
Okay. So, it's back. Okay, now I hope it works. So, yes, why you will see, well, first, Jonathan already introduced our organization, just to mention that indeed we are covering in our membership all the bars and law societies from Europe, not only the EU. We have a range of observer member states also beyond the EU, and obviously also the UK is an affiliate member. And then we have a range of observer members who are all part of our community. And so when talking about digitalization of justice, and here in my presentation, I referred to the word e-justice, just to refer basically to digitalization, what is digitalization of judicial proceedings. So that is what we are talking about today. Today we are talking about, at European level, what is being done in the digitalization of judicial proceedings, but then not just the national proceedings, because that's a national competence. We are talking about the digitalization of European judicial proceedings. And Gusta has already referred to a range of legal instruments that exist at EU level that are impacted by this. Because as lawyers, you may be confronted in the course of your work with one of these instruments, whether you should use one of those instruments. So there was one slide, which basically from Gusta Petri, which made an overview of these different legal instruments, 24 in total, both in the field of civil justice and in the field of criminal justice. For example, the European Investigation Order is a criminal judicial instrument. And it is important that, of course, defense lawyers can also ask the launch of an investigation order. And so what does it mean if this procedure, now these procedures were paper-based procedures, but when they are digitalized, the whole range of aspects come into play. And it is these aspects which the CCBE deals with in order to ensure that the work of lawyers basically is also taken into account in these processes. Now, on this slide, you see there is a long history before we came to where we are now. And here you can see on this slide just a range of projects in which we have been involved in at a European level, which all have to do in one way or another with digitalization of justice. First of all, the Find a Lawyer projects. These are our initiatives, basically to build a directory, an electronic directory, where you can find a lawyer anywhere in Europe. This directory is now available on the e-justice portal. And we used, once we had developed this directory, which is basically a search engine, which you can use if you want to find another lawyer in another member state. You can use it. You search for someone in Germany in the field of criminal law, speaking maybe also, I don't know, English, Italian, or French, and you can use those criteria to search for another lawyer. Once we had developed that, we realized that this directory actually would also be a useful tool to build what we would call a lawyer's role verification, namely a kind of digital identity tool for lawyers. So we built a kind of model for that, which we will be able to use that in future when the digitalization of justice further enhances, and my colleague Anna will come back to that as well. So we also were closely involved in the e-codex process. Gusta already referred to this. This was basically, before it was a project. It was a project among different member states, ministries of justice, who wanted to build a system to interconnect their national e-justice systems to make sure that at European level, when the digitalization of judicial systems takes place, that they can communicate seamlessly with their national justice systems. And so this was basically the e-codex model that was developed, and the CCBE was always involved in that. Why? Because there are, as I already indicated, various aspects for lawyers to be dealt with in that context. Then there were evidence projects. There was a project also just highlighted by Gusta, is the use of video conferencing in cross-border procedure. So we were also involved in a project where we basically developed a protocol of what needs to be ensured when video conferencing takes place in a cross-border procedure. Again, when we are speaking about the EU procedures, we are always talking about cross-border procedures. And so when video conferencing is used, we we were involved in order to make sure that from the lawyer's perspective, what is necessary when a lawyer also needs to be connected in a court trial via video conference. What does it mean with the communication he has to also do with the client? Is the client in prison? Is the client at the same site? What are the requirements then? How does the lawyer need to identify him or herself? So all these elements and what is needed for the lawyer in order to be properly also be able to intervene in the trial process in order to be properly visible, etc., and to produce evidence, to how to show evidence. So these things were basically addressed in those projects. And then just to quickly refer to our AI for Lawyers project, where we did also a study on the impact of AI on legal practice, and we issued a guidance on that. That is all available on our website. So I already touched upon this a little bit, but I just want to again give this overview of why then e-justice, why digitalization of judicial proceedings, why that matters to law. It might seem an obvious question, but well, of course, we believe initially that of course digital procedures can facilitate access to justice. Of course, if they are done in a proper way, they are not guaranteed. So efforts need to be done in order to really ensure that access to justice is improved through the use of digitalization, because it could also be hampered. For example, I referred to the use of video conferences. If the tools are not proper, then of course access to justice could also be hampered. So this is why we are involved as CCBE in these matters to actually ensure that it improves access to justice and does not undermine access to justice. But then there is also a legal dimension for lawyers, because of course lawyers have a deontological obligations. They have legal obligations in terms of data protection, professional liability rules, rules of evidence, etc. when they in the course of their work. And all these aspects, so lawyers need to be capable when they use digital tools to also fulfill their legal obligation and their ethical obligations, such as also protection of legal professional privilege, professional secrecy. Again, referring to the example of video conferencing, when you participate with your client and you cannot speak with your client confidentially, that principle is undermined. So these are the aspects which make it also, from a legal perspective, relevant for lawyers. Then there is, of course, there is a technological dimension. I already referred to e-identification. Then there are all sorts of technical requirements for e-filing, e-service of documents, electronic payment orders, electronic registers, access to cross-border justice systems. So all these elements, lawyers will have to be also trained and made aware about how to use those issues. So there is a technical dimension as well for lawyers. And then obviously also an economic dimension, because in the end, we hope that the digitalization of justice enhances also the work of lawyers to be able to more, in a more efficient manner, provide their services to their clients, and so that they do not encounter more difficulties. So that, for example, if their needs, the needs of lawyers, are not properly addressed, that actually, you know, their services become more cumbersome. Obviously, we don't want that. We want the opposite to take place, and that's why also this issue, the economic dimension, is relevant here. Now, then why are lawyers also relevant for the development of e-justice system? So as I indicated, there are important implications for lawyers, and therefore we strongly believe that it is important that lawyers are also fully involved in the development of e-justice system. And that's where the CCBE is for, because our organization tries to engage with these developments And of course, through our committees, we also have various lawyers that help us in expressing, in analyzing the tools, and in helping us to also indicate what the lawyers' needs are. Because eventually the deployment of e-justice systems will need to take into account citizens' rights. And as I mentioned, also various statutory and deontological duties of lawyers. And so basically they are summarized here that e-justice systems need to be secure and support in electronic equality of arms and access to justice. So in other, what does it mean? It means basically that digital procedures should facilitate all parties in a trial, and not only one party to the possible disadvantage of another party. E-justice systems also have to enable lawyers to use at least the full procedural rights that they have, that they previously had under paper-based system. And yeah, an example for that is also that according to the services directives for lawyers, lawyers is entitled to undertake temporary service in another member state under your home country title. And of course, if European procedures are digitalized, these principles should be taken into account. And you might think, well, that's obvious, but once IT people, who are very useful, but once they start digitalizing things, we have encountered, and this very principle was at the very start actually in danger, let's say, was not properly taken into account. We really had to ensure that these kind of principles are taken into account. Another example is that when using e-justice systems, lawyers have to be capable also of acquiring evidence for their acts done within the court system. So, for example, the possibility of filing and archiving electronic documents and related metadata in a reliable manner, even after the court might have deleted the original file. You, as a lawyer, you will have to, if there is any doubt at some stage about something, that you have proof of what you have done in the electronic system. And then electronic court systems should not impose technical restrictions that effectively prohibit or restrict lawyers in and their clients, and eventually from having access to justice. And one example which have popped up various times is, for example, technical size limits for documents. So that, of course, then, yeah, if a lawyer cannot submit or file certain documents because they are too big, or because the format is not correct, etc., then that is the kind of issue that obviously needs to be addressed. So yes, I think we can, well, these are also self-explanatory. So I think I can move on to, again, yeah, step back a bit and refer to what, so there was already reference made to the e-Codex regulation by Gustav Petri, and a very important principle, which I would also like to highlight in this context, is basically judicial independence, which is another big principle that needs to be ensured. Because basically, the appearance of independence is equally important as de facto or de jure independence. An e-justice system that is being perceived by its users as biased or partial will not be trusted and therefore also not be used. And so this makes it again very important that all the actors are really fully involved in building the justice system, so that it's not only the Ministry of Justice, it's also the judges involved in that, the lawyers involved in that, any other professional, bailiffs, notaries, wherever relevant, are involved in that, because that's how we believe also judicial independence can be best ensured and the system also be fully trusted. Then Well, so this is one of the aspects that is actually addressed here, what we see in the slide. It is addressed in the regulation that indeed relevant stakeholders need to be involved. So now, as Gustav Petre has already indicated, EU-LISA is an EU agency that basically is now taking responsibility for this implementation. And they have indeed also to take into account the involvement of stakeholders in this process. Another important element is obviously the cooperation among bars and law societies, because what we have seen as CCBE, we are, of course, the umbrella of all the bars and law societies. And what we have seen is that it is key for the national bars to share also good practices or bad practices that exist at national level in order for us to learn how we can overcome any problems or how we can promote good examples also at European level, and also that we share the technical expertise that exists at national level within the bars, because that is also very important, and Anna Drost will say something more about that when we go into also a little bit on the issue of e-identity. And finally, what is for the CCBE an extremely important matter is that training is also required. That's why we have now today's webinar here. But we are only at the beginning of the digitalization, even though it sounds, well, digitalization sounds like something that already is happening since long. It is long, but things are not moving very fast. And so a lot of the instruments, a lot of the things being said today cannot yet be fully used because they are not fully implemented yet. So we are, with this webinar, we are trying to already give you a general picture of what is being prepared and what will come, but the system will further be developed. And as I mentioned, there will be various technical aspects that lawyers will need to be made familiar with. Some of you already are, but others perhaps not. And what are the also with the European instruments, you know, how can you use these instruments in the best way to represent your client? As I said, there is a whole bunch of instruments in both civil and criminal law. So in civil law, I mentioned one example. In criminal law, you have also in civil law, of course, the Brussels 2B instruments on jurisdiction, recognition, and enforcement of decisions in matrimonial matters. You have the European Payment Order, you have service of documents, taking of evidence. These are instruments which one day or another you might be confronted with. And then if these processes are digitalized, you also need to be made familiar with this once this is all fully in place. So I think I can now give over to my colleague, Anna, who will give a bit more about the latest developments and work on e-justice.
Thank you very much, Simona, and thank you very much for having me. Perhaps I'll continue a little bit on what Simona was talking about, into how we work with policy at EU level, and of course. At this moment, we are looking more into implementation of these instruments. As Simona mentioned, many of them are yet to come into force. So actually the focus right now is to see how they are being put into practice and what we as an organization can do. And indeed, we work at two levels. So on one hand, we are looking at the laws and what provisions they have for lawyers to be able to do their work in accordance with their professional obligations. And on the other hand, we then work with the profession and look at the professional obligations and how they can be interpreted in a given context. And I will come back to this a little later. Digitalization has raised several implications for the profession, and one of the core ones, what Simona mentioned already, is the identification of lawyers and how, in a digital context, you can prove that you're a lawyer, how technically that is solved, and who is responsible for verifying if a lawyer is a lawyer. You heard from Jesta during his presentation that it will be possible to launch certain procedures online, not only by citizens, but also by their legal representatives. So it becomes even more important to be able to see if a lawyer is a lawyer, who does that, and how we can work on making sure that this also works in a cross-border context. So this is something that we in the CCBE are looking at this moment, and how BAS can work together, what kind of solutions will be most appropriate to be ready for these proceedings to be launched online, and so that is all ready in time so that the laws come into practice, start to apply. We are also busy with monitoring various legal procedures in different working groups and technical forums. Yes, I actually showed you a list of batches of documents, batches of legal documents that are going to be put into practice from now until about 2031. This is something that we are keeping an eye on and bringing the profession's view continuously, and making sure that the concerns and also opportunities are being raised accordingly. There is another side of digitalization, and that is with lives and procedures and all sorts of processes being brought into the digital sphere. There is a side of that we are also looking at, and that is law enforcement, and how law enforcement changes and what implications does that raise for lawyers as well. You see on the slide that we are looking at the e-evidence regulation and how it is being currently implemented. For those of you who are not familiar with e-evidence regulation, it is about requesting electronic evidence across borders directly from service providers. What until now has been regulated by various different acts and conventions between member states, it's going to be regulated by one regulation, with a significant reliance on national procedures in some of the aspects actually very relevant for lawyers. So we are currently looking at how that law is being implemented, not only on technical level, but also at national level, and what kind of national laws and procedures are being implemented, and how lawyers are taken into consideration in that. To give you an example, at the e-evidence regulation allows lawyers to request the issuance of production order, meaning that production order actually is the evidence, electronic evidence that you can then direct to a service provider. Lawyers have to be able to request the issuance of such an order according to the national procedures. So what we are currently looking at is what kind of procedures are being then implemented at national level so that lawyers are actually able to do it. And what is even more important, that lawyers are aware that they can do that. So this is one of the examples of what we are doing on the e-evidence. When it comes to digital identity wallet, it is a solution that is currently developed and piloted at EU level. And it's one solution so that citizens can keep their documents in one place, and they can also sign documents online. And there are various use cases that are possible. For lawyers, it is actually an interesting option to explore as well, and we are currently looking into the implications of the development of such a wallet for lawyers, and what kind of information can be held there that would help lawyers in their practice. Probably one of the biggest challenges in digitalization is the increased use of AI and generative AI in particular. We are very busy looking at the use of generative AI by lawyers, but also at the implementation of the AI Act. You heard from the previous speakers that is that one of the actions coming up, and Jutta mentioned it, it's the high risk classification of AI systems in the justice under the AI Act. One of the use cases under the AI Act is the artificial intelligence in the justice system. And what we are looking at is the high risk classification. And what do you call high risk? How do you determine risk? We have argued in the past that the use of AI in the justice system is almost by definition high risk, because it raises some profound questions when it comes to procedural safeguards and rights of citizens, right to a fair trial, and generally respect for fundamental rights. But there are also applications that are used in the justice system that perhaps can be explored, and what their implications are, such as use of automated translation, speech to text, and text to speech tools, etc. So we are currently looking at the implication of the AI Act, but also on AI in lawyers' practice. We have developed several guides, and some of the links I included in the slide below. Can I have the next slide? I think Simone is changing the slide. Thanks a lot. So in the CCBE, what we're looking at is our starting point is to look at what obligations apply to lawyers and how they can be interpreted in the new context. And what we're doing as a starting point is the Charter of Core Principles of the European Legal Profession, the Code of Conduct of European Lawyers, which applies to cross-border situations, and the CCBE Model Code of Conduct. Basically, what we do is that we take different use cases, we take different laws, we take different situations, and we try to interpret what professional obligations mean in this particular context. So most recently, we have adopted the revised guidelines on the use of cloud computing by lawyers, where we stress that first of all, and this is in all our work, professional obligations continue to apply. But what needs to be done is to be explained how they apply in that particular situation. So in case of cloud computing, for example, one of our recommendations is, first of all, to be technically up to speed, so that lawyers' professional competence obligation applies, and lawyers should know what technological means they have at their disposal and what implications of their use arise for their professional practice. Many of you have probably heard or followed various discussions on artificial intelligence and data processing, and there are indeed many investigations by data protection authorities on the use of data by large language models. And you might ask, well, how does it apply to lawyers? Well, you have to be aware of what privacy policies and what terms of conditions applies to use of AI by lawyers. And one of the things that we do stress also in cloud computing is that lawyers read terms and conditions carefully and are aware of data processing operations, so that they are aware what's happening to information that they enter in different contexts. I can see that Jonathan is probably going to tell me that I'm almost out of time. So perhaps I'll mention that actually our key focus at the moment is to explore those implications for lawyers and to make sure that lawyers have sufficient knowledge of what's happening, sufficient knowledge of implications, and that they actually bring their concerns to us so that we are able to discuss them together and to address them either in our policy work or in issuing further guidance. And I think I'll stop here because there are probably questions. Thank you.
Yes, indeed, there are questions. And I hope Simone is back online, because the first question may be for Simone, which is from Pierre-Henri, about how is Find a Lawyer being developed? How is it evolving? Because it seems very important for lawyers.
Yeah, so it is up and running now, and it's actually, so the CCBE with the European Lawyers Foundation developed it initially, but now the maintenance and the system is being basically hosted by the European Commission. So it is, of course, I'm now not, there are a few countries that are not covered yet, but that's a small number. I cannot tell you exactly which countries now, but I would have to look at that. But in principle, yes, all EU members states should be covered. But there are still some missing countries, but the vast majority is there. And Yeah, so this is something which indeed we believe is very useful, not only, of course, for citizens to find a lawyer, but also for practitioners to when especially criminal defense practitioners sometimes, you know, with a European arrest warrant, they might need to reach out to colleagues in another country to defend them and to challenge the arrest warrant or something like that. So it's indeed a very useful tool.
Thank you. And one last question from Ezra Salmanli, who asked a question last time. He asked this both of Gust and of you, which is really to do with video conferencing. You very helpfully pointed out all the issues that the CCBE has taken up in terms of ensuring video conferencing works. But in trials where the impact of petitions, I suppose really we're talking about oral evidence is so prominent, do you not think that being face to face with the judges has a different and more important and significant impact on the narrative, or has this boat sailed long time ago?
Yeah, no, absolutely not. I mean, this is something why we said there must be a true to life concept must be ensured. So when so first, when you still use video conferencing, it must be really as good as possible to simulate a live intervention or a live hearing. So that's first of all something that and that's why we need minimum criteria for that. Not any system can just be used or any setup. And I'm aware that in the Netherlands, there is, for example, a very methodological approach to this. So they have this true to life concept where they have ensured that the courts in the various throughout the country basically are properly set up in as much as possible, allowing the judge to see basically in the same way as in a real court. But of course, it's never as good as it is face to face. And that's why indeed we have always advocated for the fact that there can be objection raised by lawyers to use video conferencing. But the extent to which this is possible, that depends on the national procedure. So if under national procedural law, indeed, a lawyer has the right to object or a client has the right to object to be heard via video, then this is also to be respected in a cross-border procedure.
Thank you. Thank you so much, Simone. Thank you so much, Anna, both of you, for your very clear and again, very comprehensive presentations. That's really excellent. We're now going to have a break for just short of 15 minutes. Please come back. We have excellent presentations from a member state and from the Council of Europe. So we'll see you all again at 11:40 Central European Time. Thank you. See you soon. Well, hello everybody, we're back. It's 11:40 now, so we should start again, so we stick to our program. And for our next session, we also have two speakers, this time from a member state. The title of their session is How Digitalization of Judicial Proceedings Works at Member State Level. The speakers are Imbi Jürgen and Margit Lauri, both from Estonia. Imbi Jürgen has been a member of the Estonian Bar Association since 1997, and throughout her career, she has worked at several highly esteemed commercial law firms, specializing in areas such as energy, environmental, and contract law. Currently, she works as counsel in the Pan-Baltic law firm of TGS Baltic. She's held multiple leadership positions within the Estonian Bar Association, serving as a member of the board from 2016 to 2019, vice president until 2022, and she's been president since then. She's also been a member of the Estonian delegation to the CCBE since 2022, and she's currently the third vice president of the CCBE as from the beginning of this year. Margit Lauri is an advisor at the Ministry of Justice in Tallinn, responsible for the ICT strategy for the courts, the development of the court information system, and as project manager of the paper-free court project. Prior to that, she was a consultant at the Tallinn Circuit Court and an assistant to a judge. So, Imbi and Margit, it's over to you. We very much look forward to your presentation, giving us the Estonian experience. Thank you.
Thank you, and hello to everybody, and thank you for the opportunity to share Estonian experience to all of you. Just a moment.
You need to make it full screen, Margit.
Yes. So I hope everybody can see now correctly.
Perfect.
Yes.
Perfect.
So again, as a small country, our digital accomplishments have been well received all over Europe. But just to start with the basics, as I always do, we can't digitalize courts or judiciary in general without having a very strong foundation from the state. In Estonia, we couldn't have digitalized our court proceedings without a very strong electronic ID. And it's just not that we have it now. We've been having a very strong electronic ID since 2002, which is, I think, a very long time, which means that we have a lot of practice in that area, and which also means that it's very widely used. More than 60% of Estonians use ID card very regularly. For example, all our court decisions are today digitally signed. It's also possible to use mobile ID and smart ID just as an alternative to an ID card. And if you don't have Estonian citizenship, you can apply for e-residency in Estonia, which again, more than 100,000 people who have everyday business in Estonia and need the Estonian ID services. Have already done so, and it's very convenient. And I also have to point out that our ID card and our electronic signature is the strongest kind. It's qualified electronic signature, and it's the only one we have. So this is the one that all the users who, for example, want to submit documents to a court have to use. No other alternatives at the moment, and no need for the other alternatives. And it's used in private sector and all the government services the same way. Again, just to point out, you cannot digitalize judiciary without having a very, very strong electronic and ID. So in Estonia, the judiciary IT systems are based on a system called e-file, which is connected to all the other case management systems and systems that the judiciary needs. E-file is a very intelligent, huge database that contains all the information. For example, if the courts and the police need to transfer data between themselves, they actually don't transfer it. But for example, if I, from the court side, register a case or documents, then all those documents are already in e-file. And for example, the police system knows where to get the same information that they need. And one of the systems of e-file is public e-file, which is a public portal for all the citizens and especially lawyers in Estonia who need data from the judiciary. It's free for all users. It requires, as I said, Estonian digital identification. It's compulsory for lawyers, for all the local government and government agencies, which again makes it very easy for the courts to communicate with the parties, because most of the important cases, parties of the cases are using e-file, and the usage of normal citizens is also very, very high. So what is public e-file? What can you do in a public portal that's meant for the citizens and the lawyers? For example, all cases of Estonian courts are available for everyone to access, which means all the documents, all the metadata is available for everyone all the time. You can start the court case from there. There are templates, there are introductions for people how to do it. We will add a chatbot as well, and it's very convenient if you need to start a court case. You can accept documents from courts and the prosecutor's office. Again, the most common way to deliver documents in a court case is through public e-file. It's secure, it's fast, and it's easy. The portal will send you an email notification, and you know you have a document there to go and accept it. As I said, the portal is compulsory for some users. We also have a little extra motivation to accept documents from there. If, for example, if I have a document that I have not accepted from the court for more than 20 days, then I can't use the portal for other court cases as well. In practice, most documents are delivered to addressees 1 or 2 days. So it's the rule that in 20 days the system will deny you access is actually very rarely used. Of course, I can add new documents to the proceedings if I need to. I can see all the information about all the hearings with audio recordings. I can file appeals. I can pay state fee online. And as lawyers are our main users, we have special features for lawyers as well. They can share the cases with their other members of their law firm. They can access their case files if for example, somebody is on holiday, and so on. We also have automatic data check and adding, for example, if I submit new documents, I also add personal data of other parties, and I can use business register or population register for checking if that data is up to date. So of course we have document templates, as I said before, especially for the citizens, to make it easier for them to submit documents to court, and it's actually easier for courts as well because they will get maybe better formed documents than they would otherwise. We also have access to digital court files, which is actually a separate system and enables all the parties and courts, and for example, the prosecutor's office, to see a same version of court files, which is kind of like a court file in I'd say an e-book format where you can sort documents, you can comment documents, you can print it out if necessary. All that data is machine readable, so you can search by keywords or by any word that's in that file, not only documents, metadata as well. And it makes it easier for example, everyone during the hearing, because everybody has the same view of the certain court file. This was something that when we started our paper-free court project, our lawyers said that this is something they need. They can't just have access to court file, but they need this court file to be a tool for them where they can actually make comments and work. And I think this was one of the success stories of our digital court project. Our paper-free court means that today all our civil and administrative cases are fully digital. The law says that all materials have to be available in digital form, and the data, the documents that are registered in a case management system are the ones that have a legal bound to it. Yeah. So what has this public portal and our digital proceedings given us? For Estonia, digital has always been associated with the word efficiency and speed. I know it's controversial to talk about that when we talk about judiciary, but we do think that having had the success that we've had in a digitalization of court proceedings has given us a faster proceedings. We've had one of the fastest proceedings in Europe, according to Justice Scoreboard, that's published every year. All of the communication is almost all of that communication is on digital form. Less than 5% is still on paper, and having most of the communication through portal is giving the courts more efficiency through that the court clerks don't have to enter data, because most of the data that comes from the portal is already available in the case management system, and the courts don't have to enter any data. Plus, it gives the advantage that you don't make a mistake by entering data. And of course, improved access and transparency. The real-time access for everyone to their case file, again, is, I think, a very, very huge plus. Again, if we develop our IT systems, we always have to show how the system is giving us savings, and how it can improve judiciary in a whole. So we always have to make sure that we do that. For example, today, the cost of, for example, before we had a fully digital case file, we had to physically move the court file, which was actually kind of a cost. So now that we don't have to move the file anymore, we can say that we've saved a lot of transportation costs. Of course, the security and data integrity is very, very important, as all the information is transferred via e-file, which means the security level is quite high. And as the public portal is available only through secure authentication, also means that the data leaks are very, very rare. And just by exchanging data through e-file gives us, I think, the speed. It makes the proceedings faster by, for example, if the court makes a decision and the next minute parties, or for example the prosecutor's office, already have access to the data, that automatically means that we have saved time. So that's it from me at the moment. I give the floor to Imbi now.
Yes, thank you very much, Margit. It is great to be here. Thank you for having me. I'm sharing my screen now. Yes, taking over from Margit, I would like to share with you the view of a practicing lawyer who uses these digital tools in Estonian justice system. And first, as Margit's presentation concentrated on the e-file system, I would like to explain that the use of e-file system is mandatory for lawyers in Estonia since 2015. That is already 10 years. And what does it mean that it's mandatory? It means that a lawyer is prohibited from sending documents to court or other participants of the proceeding by post or by email, unless there is a valid reason. That may be a technical problem. And it means you must upload your documents to the e-file system or create the document within the system using the functionalities of the e-file system. And also documents are delivered to lawyers, also only through the e-file system. A lawyer gets a notification email from the system and must log on to the system to see a relevant procedural document. And I can really say that after 10 years, this mandatory use of e-file system is not a problem for professional lawyers. It is it's natural and it's fully accepted. And believe me, we also have all kinds of age groups within our lawyers, but by now everybody has really got used to using this system. And of course, when the system was introduced 10, 15, 20 years ago, then there was reluctance and there was some resistance. And that was all mainly due to technical problems, which always occur when you are just developing or starting a system. But by now, I can say, and I'm quite happy to say, that these technical problems are really quite seldom, and there are no major pushbacks. So therefore, the lawyers have really learned to use the e-file system, and it really saves us a lot of time. And we also believe that it is a very secure way of exchanging information. But of course, the e-file system is just one element of the wider digitalized system of public services. And I have a few examples that I would also like to introduce to you, which are all very important for practicing lawyers in Estonia, enabling us to exchange information and to communicate with the government, with local authorities, and also with private parties smoothly. And some of the elements are public and they do not require any identification at all. But all these systems or platforms are accessible by means of electronic ID. It is the same electronic ID that Margit mentioned. There is no need for other kinds of identification means in Estonia. So once you have your electronic ID, you can access all these systems. And what is also characteristic to Estonia is that there is no lawyer-specific digital channel or platform, a platform that could only be used by lawyers. Like in some European countries, there are, or information channels or communication systems for lawyers specifically. We lawyers, bar members, when being active professionally, we use the same databases and platforms and digital services as other members of the society can use. So there is no specific platform for lawyers. And these services together form a digitalized ecosystem, enabling us to perform our professional tasks when advising and representing clients. And here at the slide, you can see I have listed perhaps the most important ones that we really use in our daily activities very actively. First of all, of course, the State Gazette or Riigi Teataja, which publishes the national legislation, municipal regulations, but also all judgments made in Estonia which have entered into force. They are, if relevant, they are anonymized, of course. But they are accessible to everybody. And this is a wonderful, really, database. This State Gazette, it ensures that all laws are really up to date and accessible to all. And it's public and free of charge. But based on this database, there is nowadays also a commercial app called X-Law, which is very, very popular among us Estonian lawyers, which also includes some AI tools, which enables us to really, really easily search in the database and make inquiries. So this is really, really very useful and very widely used by Estonian lawyers. And then we, of course, have this e-business register, e-land register, and also e-tax and customs boards. which also are very, very widely used, and which enable us to do our work really quite smoothly. There is this a specific system, e-notary, which is actually a tool for notaries, which is not for public use. It gives the notaries access to 16 registers, which they need to do their work. But this one part of this e-notary system is also remote identification to participate in notary transactions virtually, which it was launched during COVID, and it has proved to be very, very useful, really enabling people to appear at the notaries, not in the notary's office, but from their homes or offices, which is sometimes very, very useful and saves a lot of time. And of course, it was sometimes the only opportunity during COVID restrictions. So all these tools we use, and we are quite happy about it, and quite proud of ourselves in Estonia with all these digital tools. But of course, as every system, also there are problems, of course, also with all these wonderful digital tools, and I will just very briefly mention some of this. Of course, there is the issue of digital divide. It exists also in Estonia, although we have very high rate of digital literacy, but also, of course, we have individuals without reliable internet access, digital literacy, or access to necessary technology. And also, as Margit mentioned, about 5% of court proceedings are still on paper. So it has to be noted that the use of e-file system and other public services platforms, it's not mandatory for private individuals. It's mandatory for lawyers. But of course, even if you can file your application or communicate with the government or local authorities on paper, that is definitely not as smooth as by digital tools, which definitely means that it's not equally smooth. All these proceedings are not equally smooth to all people, and the government, of course, has to make sure that there is assistance, proper assistance to these people. For example, there is this wonderful project in Estonian libraries, because there are libraries all over the country, and people are used to going in libraries. So their library workers, library employees are trained to help people to use these digital tools. But also there is technical problems with internet access, even in Estonia. Not all the areas are covered with high-speed internet access, and that means that not everybody can access all these digital services from their homes or offices. So this is a big area for development, definitely. So then
you see me in me, not for any bad reason, but your joint presentations have generated a lot of questions. So I'd like to take as many as possible. So if you can conclude as quickly as possible, we will go to the questions. Thank you.
Okay, so a few things to mention. Cross-border. In the beginning of this webinar, we talked a lot about cross-border use. And in Estonia, that is not smooth yet. So there is, most of these e-services are accessible only to persons who have Estonian ID card. So there is a lot to be done there. And also sometimes we have noticed technology prevailing over law, and what this is a danger, and we as lawyers must be very careful here, because sometimes a law gives people a right, but they cannot effectively enforce this right because there is no proper technological solution. So the function is not developed for a particular app or something like that. So we have seen that, and that is also one problem that needs to be taken care of in the future. But yes, please, we are open to questions now.
Fine. Thank you so much for stopping early. So there are 3 questions. I hope you'll find them on the question and answers from James Heaney. I'll put them all together. How do you file an affidavit using public e-file? How much information is extracted into the system from the filings? How much is just PDF filing of documents? And if everybody can see the documents, how do you prevent libel proceedings, defamation proceedings? So if you forget any of them, I'll come back to them. But maybe you could take those 3 questions from James together.
Maybe I'll start because when Imbi was talking, I was already
Right.
going through the questions.
Yes.
Maybe to start from the end, as I mentioned, if the document is added to the case file, all documents are OCR'd, which means all documents, even if they are just presented as a PDF, are actually machine readable. So I'd say all of the information is extracting into the systems in a metadata form as well. For example, if a citizen or a lawyer submits document through e-file, they can upload a file and then add necessary metadata. For example, who are the parties, what are their, for example, addresses, what type of documents am I uploading? So I guess that's the answer to maybe the first question. If Imbi wants, he can maybe add something in the end. And what was the last one? If the certain case file is, of course, accessible, or you can access the case file through public e-portal only if you are the party. The court will add the persons who are parties of the certain case file. And again, that's why I said that it's important to have an electronic ID. If you have it, I can add you by electronic means and you can access it. For example, if you are not Estonian citizen or you don't have e-residency, then I can add the data, but as you don't have our electronic ID number, then you can't access yourself. Some of the systems in Estonia already allow European citizens as well. I think business register is one, but our case management system and public e-portal at the moment still doesn't have that opportunity, but we are moving towards that. For example, very soon, I think Finnish people, again, first one who can access our systems. And just as other European countries develop their electronic ID, we can now move forward and allow access to our other European citizens. But just court case files at the moment, not yet.
Just one follow-up before you speak, Ibi. Christian Collinet has asked exactly that question. If you've got an EU ID, you've answered the question, no court files, but can you consult the state gazette about national legislation with the EU ID card? Ibi, sorry. You want to say?
Yes.
I will maybe add the link to that question later.
Thank you. Imbi.
Yes, in order to get access to the State Gazette, you don't need any identification. I mean, this is publicly, you can use it. You don't have, it's free for everyone, so no need for any identification means at all. That is also the case with the business register. For it's almost all the information there is public, and you don't need to identify yourself. You need to identify yourself if you want to make changes, of course, regarding one company, for example. Then of course you have to identify yourself as a representative of this company, and then you can perhaps file some documents or make changes. But in order to get access and view what's in the register, you do not have to identify yourself. I would like to add, perhaps I'm not so optimistic as Margit was, how much information is extracted into the system from the filings. It is indeed true that all this information is in the e-file system, but if the judge starts to generate the judgment, or if I, as a lawyer, would like to generate a next document in this proceeding, an appeal, for example, then there is no such functionality that the system creates texts itself. It would be the next step in the development of our system. And I would also like to mention that in Estonia, we do not yet use artificial intelligence in court proceedings, not yet.
Interesting. Two linked questions. Sorry to put them together, but there's so many. Does an electronic judicial file coexist with a paper file, or is there just one single digital file? That's one part. And then does the lawyer have access to the complete digital file? Does the court handle exactly the same file as the lawyer? And how is the file organized? Chronologically, by subject? So put a few questions together. Go ahead.
Yes, maybe again, starting from the last one. Sorry, the first one. In civil and administrative cases, all files have to be in digital form. So if something is on paper, for example, some evidence, it's kept in the court and you can see it, but there's no official paper file, so only digital files. In criminal cases, there are still parallel systems that most of the documents are in digital form, but the paper file also still exists. But yeah, in civil and administrative cases, there are only digital files. And for example, parties see mostly the same version of a digital file, but there are exceptions. From the court side, I can say, for example, that document has business secrets in it, so only one party can see it. So the court is kind of the owner of the file and can regulate who can see what, but mostly everybody sees everything. And it's in chronicle order, but you can change it whichever way you like, for example.
And again, before Georgios Gavrielidis has asked, if it's cases of a great public interest, can journalists have access, or is it just the parties? Sorry to interrupt you, Imbi.
Just parties, but there are a journalist can ask court's permission to access the file, but at the moment we don't have a very good way of giving electronic access. So we will make a version of that file in a PDF form.
Imbi, sorry, do you have any further comments on those points?
Well, the media can always come to the court hearings. These are public in Estonia, but access to the file, it is really, really exceptional. After the process has ended and the judgment has entered into force, then after that, it happens quite often that media has at least partially access to the file too, but not when the case is still ongoing. Then the media is welcome in the hearings, but cannot access the file. That is usually the case.
And one last question, we must move on from Ezra again. It's if there's some physical evidence, a blood sample, so it can't be digitalized, it has to be physically sent off. Is this notified in the digital file that it's arrived, it's been sent off, the test has arrived? That's all digitally filed, even though there's a physical part to it.
Yes, and the physical part is usually kept, depending on the case, in the court, or if it's a criminal case, it can be in the prosecutor's office or police. So yes, something usually in the file that indicates where this object is. There is a separate evidence system and that actually logs where certain cases, but it's only in criminal cases. And there's information to that in the case file.
I don't know if you have anything to add, Imbi, to that. Otherwise, no, thank you. Thank you, both of you. The number of questions is the evidence to the excellence of your presentation. And in fact, I'd like to set you both homework, because if there are other questions in there addressed to Estonia, if you could answer them in writing briefly, that would be very helpful to our participants. Thank you. Thank you very much indeed. But we must move on with our program. And our next session is the work of the Council of Europe in digitalization of judicial proceedings. And our speaker is Maria Giuliani Sivanini, who since January 2020 has been the president of the Working Group on Cyber Justice and Artificial Intelligence of the European Commission for the Efficiency of Justice, which goes by the acronym of CCBE at the Council of Europe. She's been a judge in numerous courts in Italy and elsewhere since 1983, in civil law and labor law in Modena, in criminal law in Pistoia. Then she was a referendary councilwoman at the Supreme Court of Cassation. She's been a member of the High Council for the Judiciary, the Consiglio Superiore della Magistratura, which is the self-governing body of the Italian judiciary. And after that, she was a judge of the Supreme Court of Kosovo, trying war crimes, terrorism, and organized crime. She's also been a co-agent of the Italian government before the European Court of Human Rights. Most important of all, she's undertaken extensive training on judicial matters throughout her career, including on our topic of judicial proceedings. So, Maria Giuliana, I hand over to you, please.
Thank you, Mr. Chair. I don't see the button for sharing the screen.
That's because we need to ask Imbi to take down her slide. Yeah. Please, Imbi, can you stop sharing yours? There we go.
So, first of all, thank you very much to the CCBE and to the European Lawyer Foundation for inviting me to this very interesting and important seminar. And because I will talk about Council of Europe, let me start with congratulating lawyers, European lawyers, for finally obtaining an international convention on protection of lawyers that have been adopted by the Council of Europe this month and open to signature. Apparently, it is very needed, and the CCBE has been one of the association who has made a fantastic job on this. An overview, I will present the work of the Council of Europe and especially of the CCBE, the European Commission for Efficiency of Justice in cyber justice and artificial intelligence in new technology. I will present also very quickly the context of this work and the background for the adoption of guidelines and recommendation. You know, each of you know very well the Council of Europe, this that gather 46 member states. And but I want to underline, because the Council of Europe is a really complex machine, that we work through a complex of tools. We have standards that are the recommendation, the convention, the guidelines, monitoring mechanism that includes the European Court of Human Rights, and cooperation program assistance that allow member states to reach the standard that are adopted and verified by the European Court of Human Rights. The Commission for the Efficiency of Justice has been established around 25 years ago, and has the goal to promote the rule of law and fundamental rights on the basis of the European Convention of Human Rights, and supporting member states and individuals in the improvement of the quality and efficiency of justice. We have several fields of intervention, and I will focus on cyber justice and new technology. In 2022, the CCBE, the Commission for Efficiency of Justice, adopted an action plan 22-25, establishing as priority digitalization, supporting a successful transition toward digitalization of justice. And why? We know that because you are lawyers, but we share the same culture, judicial culture, that the need of justice has accompanied humanity since antiquity, and it's a field in which customs, ritual, rules are intimately part of the trials. But even in this area, so marked by tradition, technology can play a pivotal role. We often discuss about great opportunity that technology can offer us in document management. We just heard about digitalization of civil and administrative case in Estonia. But we have to face also challenges. Adapting traditional practitioners is the first one, not only on judge's side, but also on lawyer side. And we have we are always aware that we cannot jeopardize impartiality and independence, and that the protection of fundamental rights must remain with all the embedded value at the core of our activity. And we know the risk, because this is a huge debate nowadays, about biased responses, discrimination, disruption, oversimplification, and disruption of rule of law. We also had the lesson from the COVID-19 crisis, and we saw that only the jurisdictions that were highly digitalized and could face and grant justice in this sector. Why we have to move, and we need to improve our knowledge and to be open to technology. That is in my opinion, essential for our traditional profession. I quote here a survey of last year's survey of Paul, Leonardo da Vinci, and Talan. And if you see it, if you watch to the answer that students of this huge education poll gave, we see that 99% of students use AI, and 92% regularly. They are ready to spend in technology. They see a lot of benefits in using technology. This means that these young that are now in school will be the client of lawyer in the future. They will be lawyer and judges in the future, and we have to be ready for this new approach to life, to society, and also to law. And many report and survey discuss the attitude of lawyer. I'm quoting here one that I esteem particularly scientifically based, but we have many other Walters Kluwer Future Ready Lawyer Survey report, the Smoke Balls State of Law Report 25. They all show that lawyers are ready to adopt technology, even if they remain very cautious and see serious challenges in legal issue, privacy, reliability of this new system, and they are aware of a need of policies, training, and improved security. But already in the field of automating document, processing document, and legal research, technology and even artificial intelligence are having an important role. CCBE in the last 10 years has adopted important document. I want only to quote the European Ethical Charter or for the use of artificial intelligence in judicial system, because this has been the first ethical charter and has played an important role in the future evolution. But because of the awareness of specific tool and activity, in 2020 has been established the CCBE Cyber Justice Working Group. The CCBE is observer, a very active observer, who has a specific mandate to create and to adopt, to propose to the plenary of the CCBE the adoption of tools, very practical tools, and to explore the challenges posed by digitalization and AI. The focus of the working group in view of adopting guidelines have been and are still video conference, digitalization strategy, online enforcement of judicial decision, online dispute resolution, case law database, legal knowledge. We have already adopted several guidelines. You can see in the slide there is the list, and you can find all of them on the website of the Council of Europe. And it's important to underline that guidelines that don't introduce new rules. They are soft law. The guidelines are soft law, and they provide suggestion and guidance to the member states and to all the judicial actors who want to adopt a technological solution in line with the European Convention of being in line with the European Convention of Human Rights. But what is important is that even if it's simply soft law, even if they are not new rules, they are the European standard against which we can check the quality of new legislation, new adopted tool that can be used in project and activity. The first guideline I want to shortly present to you is the guidelines on e-filing, how to digitalize justice. It's, in my opinion, a fundamental tool for each member states who want to digitalize justice. And it's even more important because now we have the tendency to take a shortcut, meaning there is who think that via artificial intelligence we can solve many problems of justice, but only through digitalization. And I quote what Margit just said, it's only through digitalization, database, electronic tool that we can have a system that is open, accessible, and quick, and of high quality. So the guidelines are composed by fundamental principle, key concept, definition, and you can find governance, organization, and technical aspect, and they are complemented by a list of recommendations and a technical checklist that is really a practical tool. If you have certain technology in your country, you can obtain certain kind of result. If you want a certain kind of result, you have to adopt the suggested solution. When we talk about e-filing in the context of this guideline, we talk about solutions that facilitate access to justice, establishing a digital channel that enables the interaction and exchange of data and e-document between court and court users. An example, again, is the Estonian one or the Italian one, if you wish. The purpose is to design, fix the key measure needed for design and implement a framework enabling the party to start a judicial proceeding, issuing and receiving e-document, exchange procedural document, send, receive e-notification and e-summons, pay court fees online, access a secure repository of all procedural documents. The keys to a successful digital transformation are many: a good legislation, a government overall strategy, but I wanted to stress the last one, involving the stakeholder, meaning judges, lawyers, notary, all the professional of justice, because without us, without you, is not possible to have a successful transformation. And I have to say, because in Italy too, we have a digital civil and administrative justice by default, no paper by default, that the role of lawyers has been really the key to a quick and successful transformation. Two guiding principles: changes in the field of cyber justice shall be court-driven and not technology-driven. The solution must always be in line with the core value of justice. Another we consider important guideline that have been adopted, has been the first guideline adopted by the CCBE, is the one on video conferencing in judicial proceeding. And the reason is clear. We started working in 2020. The COVID we had immediately the COVID crisis, and member states were asking some for support in this field. The guidelines are composed of a set of key measures to ensure that the use of video conferencing judicial proceeding doesn't undermine the right to a fair trial. And the main principles are based on the case law of the European Court of Human Rights on Article 6 of the Convention. In this guideline, you find fundamental principles rooted in the European Convention of Human Rights and the case law of the court. The main procedural issues are addressed with recommendation, and technical and organizational requirements are listed, and a collection of best practices support the guideline. In the next plenary session of the meeting of the CCBE in June, we, as working group, we will propose the adoption of a practical guide on remote hearings that is a kind of addendum. It started like an addendum to the existing guideline, but has enlarged its scope, including including a revision of statistics on the use and on implementation and use of video conferencing in the country of the Council of Europe. What we have assessed is that the adoption of tools and both tools and legislation is wide. Remote hearing capability are now widely available, with the highest adoption in criminal and civil and commercial cases. 35 countries on 46 for criminal and 34 for civil. But at the same time, the usage is very low, even if the infrastructure apparently are mostly in place. Clearly, there are still barriers to usage. Some of them have been quoted by the colleague from Estonia. There are feature gaps, limited private consultations raises privacy concern. There are inconsistency in simultaneous interpretation. There is an important impact on non-native speakers, and there are all the worries linked to the right of defense that also Simone mentioned before. And there is not a unified approach regarding the need of consent before implementing remote hearing. This I want just to add that this document that will be adopted in June contains a very interesting overview of and complete overview of the case law of the European Court of Human Rights, and many examples of best practices. Another relevant guideline is the one on judicial auction. I know that every of you know what is a judicial auction, and the e-auction is an auction with the intervention that work through a digital platform, whether public or private, that is also used for advertising of the foreclosed asset on sale. The structure of this guideline that is very detailed, and I think it is playing an important role in countries that don't have yet a proper digital platform, contain both principle, a clear definition of benefit and risk, and a list of best practices and a checklist for quality control of a auction. Another sector who has been interested by our activity is the alternative dispute resolution. Probably you know that in the Council of Europe, many guidelines are related to this subject. But what we observed is that during the pandemic, again, the need to continue the activity has pushed the introduction of digital tool and the use of digital means also in this in the sector of the dispute resolution. So this is the reason for this new guideline. I wanted to only to underline that when we talk in this context of alternative dispute resolution, we refer to all the method, conciliation, mediation, court-annexed mediation, to resolve a dispute without recourse to litigation. The structure, I think now you are a bit familiar with our guideline. We have definition, purpose, scope, and guidelines, recommendation, and a list of best practices from member states. A very important guidelines, of which I'm particularly proud because it was very difficult to achieve, is the guideline on online publication of case law and legal knowledge access. This guideline have been adopted in last December. They are based on a study on digital publication of court decision, a comprehensive survey that has received an important number of answers and reply, and that the answer that we received from member states are with all the relevant document and legislation, the base for these guidelines that address the design and implementation of an online legal database of judicial decision and the public access to this database, providing member states with practical, methodological, technological, and organizational advice. The target is not only the authority responsible for administration of justice, but also the court and all professionals and parties who are must be interested to know how the database are composed, especially when they are used to research that are pushed with AI-driven research tool. And the database is exceptionally important. We talk a lot about prediction. We know that Nobel Prize for chemistry and physics have been possible because of the use of artificial intelligence search tool applied to enormous, monstrously enormous database data clean data and information. And this apply also to justice. There is a lot of marketing about predictive justice tool, searching tools for case law of court. But if the database that are the base of this research tool are not broad enough, are not properly created and organized, the information that come out are absolutely not reliable. And this can be a huge challenge for judges and for lawyers. The purpose is clearly, and it's these are too long and too complex guideline, and I cannot go through them. But I want only to tell you that one of the main principles is that a proper case law database has been composed of all decisions, not a decision selected by chief of court, minister of justice, or whatever other authorities in the field of justice, less a commercial company who decide which decision can or cannot put in a database. If we want to have a database with a role in the evolution of justice, in understanding of justice, in understanding of our right, we need complete database. Complete meaning all the decision, even the less important and the most repetitive of them. And they have to be complete document, not abstract or summary of document. I go to the last part of my presentation. Just to tell you that an important activity of our working group of the cyber justice is sharing knowledge, creating collaborative knowledge, cross-disciplinary sharing between legal profession, among legal professions, building robust communities of practice. And this goal is achieved through some tool that I simply list. The European Cyber Justice Network, who is composed by representatives of all member states. And I will tell you that we have a very interesting webinar series that you can find on our website. We have adopted a glossary of technology terms for judicial profession because we have assessed a need to have a common language that we understand of what we are talking about. And the group is supported by the Artificial Intelligence Advisory Board, composed by professors who are especially dedicated to this field of knowledge. We have created a resource center. I will tell you if I have one last minute. We are producing informative document like the information note on generative AI in the justice system. How should it be applied? And even more important, when should it not be applied? With a series of synthetic essential information and some suggestion. And we know that our document is used by many institutions to create their own guideline to the use of generative AI by their staff. The Resource Center, I have to tell you something about this because it's really an important tool. We heard the first speaker, Carl Gosta Petri, talking about the willing of the European Union to create a repository of digital tool and AI tool. But we are already working on it since few years. And if you will visit the website, our website, and the Resource Center on Cyber Justice and Artificial Intelligence, you will find that country by country and topic by topic, user by user, the most relevant tools that are in use in justice system in Council of Europe member state are listed. We have selected out of the totality that Jonathan, I'm finishing. Right. And I'm only inviting you to go and check, and we have already a first report by the advisory board on this. If I have 30 seconds, I will give you my personal point of view. I think that the robot, we shouldn't even talk of robot judge, because we have a constitutional tradition. We have European Convention of Human Rights and our constitution, in which has been chosen to have human judges and the human judiciary as one of the power of the country. I think that lawyers should be very careful when adopting generative AI. And finally, I want an AI that support me in doing minor work, repetitive work, not the fantastic job that is deciding or for a lawyer defending a client. Thank you very much. And I'm ready to answer a question. If,
yes, yes, there are a couple of questions. Thank you. Thank you so much for your excellent, very clear and comprehensive presentation. But there are a couple of questions, as I say. So let me just go to them. Oh dear, there it is. I had them open, but now I can't open them. The first question, something's happened to my question and answer session. The first question was to do with whether you favor, it's come up. Oh, I'm so annoyed with this. My question and answers have disappeared. There they are. Right. From P. de Vries, asking first of all whether it's necessary to have additional or better European or national rules. But are you in favor of, here we go, strict rules or open standards?
I think that we need both. We need rules because fundamental rights are at stake. But to have a general framework of principle that have been embedded in all AI tool and also digital tool is the priority. And I want to mention the Framework Convention of the Council of Europe that play this role, not introducing new rules, but giving the main principle that have to be adopted and assessed when creating new technological tools.
Understood, thank you. And Ezra's asked a question saying, and this is to do with e-auctions, about whether we can say that our means of proof for bid rigging or bid rigging or collusive tendering, have the means of proof narrowed now that it's on it's an e-auction, and now that there are rules on e-auctions? Is it the same as it was before, would you say?
No, I would say that using a platform is not changing the nature of the auction or the procedural rules. It's only what is needed to adapt the contest from paper to digital, and that is changing, and not the main rules that are in this, and especially the standard of proof.
Perfect, perfect. Thank you so much. I must say, your slides are very, very full of information, and therefore, people who want to know more about what you've said, look at the slides that Juliana has very helpfully prepared, which have got many links and much information, and will be on our webinar. We've absolutely arrived at our time limit on the dot. Thank you, Juliana, very much again. And if I could just give a symbolic round of applause for all our excellent speakers, and for you, our participants, for your many excellent questions as well. Thank you very much, and we hope to see you again soon when we hold another webinar. Thank you, everybody, and goodbye.
Thank you. Goodbye.